In a recent White House press briefing, senior officials outlined a comprehensive strategy to eliminate foreign terrorist elements and safeguard American communities. Emphasizing both diplomatic partnerships and legal rigor, the administration reaffirmed its commitment to deporting individuals affiliated with designated terrorist organizations. Central to this approach is a series of agreements, most notably with El Salvador, designed to receive thousands of such individuals, alongside similar arrangements with numerous other countries. By doing so, the government aims to sever the operational footholds of foreign terrorist organizations, FTO, within US borders and strengthen international counterterrorism cooperation. The legal underpinning of this strategy was bolstered by a unanimous Supreme Court decision which vacated a lower court's directive compelling the administration to negotiate the return of a specific national. The Supreme Court unanimously held that district courts lack authority to mandate diplomatic or foreign policy actions, thus restoring executive discretion in removal proceedings. This ruling clarifies that decisions regarding deportation destinations remain within the sovereign purview of receiving nations and not subject to judicial micromanagement. Fundamental to the administration's policy is the clear distinction between a deportation order and a withholding of removal order. Under Article 2 of the Immigration and Nationality Act, an illegal alien may be ordered removed without temporal or geographic constraints, whereas Article 3 judicial restraints, such as withholding or cancellation of removal, apply only in limited circumstances. Crucially, withholding does not apply to individuals deemed members of FTO. This parallels long-standing practice that denies safe haven provisions to terrorists, regardless of their claimed persecution. Despite these clear legal parameters, media coverage has frequently perpetuated misunderstandings. Contrary to reports of errant deportations, no individual was mistakenly sent abroad. The sole administrative misstep involved a clerical error in a legal filing, promptly corrected with the responsible counsel relieved of duty. The person in question is an El Salvadorian national who received a final removal order and, accordingly, was processed for return to his country of origin. This addresses the erroneous narrative that a wrong person was deported, when in fact the case adhered strictly to immigration statutes. And once removed, the welfare and management of returning citizens fall entirely to the host nation. It is neither feasible nor constitutionally permissible for the United States to conduct day-to-day oversight of deportees' housing, healthcare, or social integration. To impose such an obligation would exceed the scope of diplomatic engagement and infringe upon another state's sovereignty. Analogous scenarios, such as potential removals to Syria or Haiti, underscore the impracticality of comprehensive post-deportation monitoring by U.S. agencies. Should an individual attempt re-entry, U.S. law provides for immediate apprehension, detention, and reinstatement of the existing removal order. Subsequent re-entry would trigger a fresh deportation process, potentially accelerated by prior determinations of ineligibility. In hypothetical cases where withholding orders might exist, statutes permit removal to alternative countries, yet the normal preference remains return to the individual's homeland. This mechanism ensures that FTO members and other priority removals cannot exploit legal loopholes to remain in the United States. The briefing also highlighted a notable gap in the media's legal literacy. Reporters repeatedly conflated deportation with withholding, overlooked statutory distinctions, and failed to recognize that no judicial injunction blocked removal. Addressing this knowledge deficit is essential for accurate public discourse on immigration enforcement and national security. A sobering case study emphasized the gravity of procedural decisions. 2 Venezuelan nationals, initially placed on supervised release despite allegations of severe misconduct, later abducted and ruthlessly murdered a 12-year-old girl, Jocelyn Nungiri. The administration contrasted the extensive due process granted these suspects with the irrevocable loss suffered by the victim's family, underscoring the stakes of release versus removal. Similarly, challenges persist in sanctuary jurisdictions, where local policies can shield dangerous offenders. One recently arrested pedophile, an illegal alien alleged to have committed more than 20 sex crimes against minors, remains under local protective statutes, complicating federal removal efforts. The administration stressed the emotional toll on victim families who face repeated offences by shielded individuals and affirmed that public safety must take precedence over sanctuary protections. Transnational gangs and cartels continue to threaten communities across the country. Ms. 13 members prioritised for removal have entrenched themselves in certain neighbourhoods, enforcing extortion and violence. Concurrently, Mexican cartels dominate drug corridors, flooding US streets with fentanyl, often laced into ostensibly benign pills. This crisis has claimed thousands of young lives at social gatherings where unsuspecting individuals suffer fatal overdoses. The briefing underscored that decisive removal of high-risk aliens is a critical component of national security and community protection. On the diplomatic front, the president's first-day executive order mandated an interagency review spanning the Departments of Homeland Security, State, and Intelligence to identify foreign governments that meet U.S. vetting standards. While the State Department has completed its initial assessment, the report remains under standard internal review. Officials promised a forthcoming public update, reinforcing the administration's intent to calibrate visa restrictions in line with national security imperatives. Fiscal considerations also informed the discourse. Long-term incarceration within the United States can cost upwards of 100 times more than deportation proceedings, which often incur minimal per capita expense. By expediting removal of criminal aliens, the administration projects significant savings for taxpayers while reallocating resources toward rehabilitation and reinvestment in domestic priorities. Early estimates suggest the lives saved and budgets preserved, since enforcement enhancements number in the thousands. Finally, the investigation revisited human trafficking under the previous administration, which saw approximately 500,000 minors smuggled across the southern border. Reports of systemic failures, ranging from inadequate oversight to active subsidization of traffickers, drew sharp criticism. Current efforts to uncover sex and labor trafficking rings have revealed conditions of unspeakable abuse. The briefing concluded that had American citizens perpetrated such crimes, they would face life imprisonment, yet numerous illegal alien offenders have evaded swift justice until now. In conclusion, the administration's reinforced removal policy represents an essential pillar of national security and public safety. By leveraging legal authority, diplomatic agreements, and fiscal prudence, federal agencies aim to dismantle terrorist networks, curb gang influence, and stem the tide of drug-related fatalities. This investigative report affirms that rigorous enforcement, grounded in the rule of law, remains the cornerstone of protecting American communities. To reinforce this framework, the administration has instituted robust oversight mechanisms within the Department of Homeland Security. Independent review panels now evaluate detention and removal procedures quarterly, assessing compliance with both statutory requirements and international human rights norms. Human rights. These panels include legal experts, former judges, and representatives from allied governments, ensuring that policy execution aligns with the rule of law and diplomatic commitments. Detailed reports will be submitted to Congress, enabling legislators to track performance metrics such as removal rates, average detention duration, and incidences of due process deviations. Interagency cooperation has likewise been strengthened. The Departments of State, Justice, and Homeland Security share real-time data on high-risk individuals through a secure intelligence network. This system flags known affiliates of designated organizations, allowing Border Patrol agents and immigration judges to coordinate actions swiftly. By integrating biometric databases and travel history analytics, the government can identify patterns of cross-border movement that signal emerging threats. Such data-driven targeting reduces reliance on ad hoc decision-making and minimizes errors in identifying priority removal cases. Community engagement remains a critical complement to enforcement actions. Federal outreach teams collaborate with local law enforcement, victim advocacy groups, and faith-based organizations to provide clear guidance on reporting violent offenders, AFANDers. These partnerships facilitate witness protection measures and support services for survivors of crime attributed to illegal aliens. Educational campaigns underscore the illegality of harbouring fugitives and the availability of anonymous tip lines. By empowering communities to participate in public safety efforts, the administration seeks to break cycles of violence and foster trust in federal initiatives. Looking ahead, the administration encourages legislative refinement of immigration law. Proposed amendments include expediting judicial review of removal orders, expanding ground-level data collection for criminal alien tracking, and clarifying the scope of withholding of removal exceptions. These reforms aim to codify best practices observed during recent enforcement surges and ensure statutory alignment with evolving security challenges. Congressional debate will determine the permanence of pilot programs, such as expanded electronic monitoring for released aliens, and the extension of deportation agreements to additional partner states. By combining rigorous oversight, interagency synergy, community collaboration, and legislative enhancement, the administration endeavours to sustain an immigration enforcement regime that is both effective and principled. This comprehensive approach underscores a commitment to upholding national sovereignty, protecting vulnerable populations, and preserving the integrity of U.S. borders.